Ms. Rothstein, did you want to talk to somebody in Ingham County Jail Post?
Well, I need to speak with Tommy King, Daniel Moyer, and Tyrone Brown. Although I did speak with Daniel Moyer yesterday, and we were going to waive the 21 days, so I don't think I do actually need to speak with him. Just Mr. King, there's an offer for, and Mr. Brown.
So is Mr. King in post 1, or is post 1 or post 3? Do we know? Well, sir, can you please identify yourself in post 3? Mr. Sartz, is that your client?
No, Mr. Thayer is in visit 5. They double booked Mr. Thayer and Mr. King, which is why, respectfully, Your Honor, if we could just get Mr. Thayer out of here, that might free up Mr. King.
Might. Yeah. All right, let's go on Mr. Thayer.
Thank you, Your Honor.
That'll. All right, so we're on the record. So Mr. Thayer, we'll call your case. We're on the record in docket 26-01521. That is people of the state of Michigan versus William Thayer. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Ingham County Prosecutor Dan Smith, appearing on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the 4th Assistant Public Defender, here on behalf of Mr. Thayer. Mr. Thayer is appearing by Polycom this morning. I'm appearing in person.
All right, and sir, you are William Edward Thayer, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Thayer?
Yes.
All right, thank you. This is the time set for a probable cause conference. How are we proceeding, Mr. Smith, or would you like to defer to Mr. Sartz?
I'll defer to Mr. Sartz.
Mr. Sartz.
Thank you, Your Honor. Mr. Thayer requests his preliminary examination as scheduled. There is an offer on the table, Your Honor. It's a rather lengthy offer, but at this point, Mr. Thayer requests his preliminary examination as it's currently scheduled. We have discovery. We'll be ready to go next week.
All right. So we're going to leave on the previously set preliminary examination for June 25th at 8:30 at this probable cause conference. June 25th at 8:30, that'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 26-01521, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Sartz.
Nothing further, Your Honor. Thank you.
All right, Mr. Thayer, we'll see you June 25th. So we'll see you next week at 8:30. Thank you for your appearance today.
Thank you, Your Honor.
You're welcome, Mr. Thayer. All right. And sir, in post 3, what could you please identify yourself? In Ingham Jail post 3, could you please identify yourself? I don't know if his audio is on. You may have to get closer to the mic. Yeah.
Daniel Moyer.
That's Mr. Moyer.
Moyer. All right. And Ms. Frosty, do you say you need to speak with Mr. Moyer? You've already spoken with him.
I spoke with him yesterday. We don't have all of the discovery yet, so we were going to waive the 21 days.
All right. All right. Mr. Smith, how are we proceeding today?
Yes, we can call that case, Your Honor.
All right. So Daniel Moyer. We lose Mr. Moyer. All right, so we're on the record in docket 26-01554. That's people of the state of Michigan versus Daniel Moyer. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Ingham County Prosecutor Dan Smith, appearing on behalf of the people of the state of Michigan.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Moyer, who is appearing via Polycom from the Ingham County Jail.
And sir, you are Daniel Moyer, is that correct?
Yes, sir.
All right. And you can hear me all right, Mr. Moyer?
Yes.
All right, thank you. This time set for a probable cause conference. Mr. Smith, how are we proceeding?
Thank you, Your Honor. At this time, I've spoken with defense counsel about this case. She has explained to me that there may be some outstanding discovery. Our office does not have that discovery at this time, but we will look into that. From my understanding, the defendant has agreed to waive the 21 day rule, and we would stipulate to an adjournment of the next preliminary exam and hold the preliminary exam at the next available date.
And is that a fair statement, Ms. Rothstein?
Yes, it is, Your Honor.
All right. May I inquire of Mr. Moyer of his waiver of the 21-day rule?
Yes, you may.
All right, Mr. Moyer, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish to waive your right to a prelim within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so that we could look at some outstanding discovery and Ms. Rothstein would zealously be advocating for your defense. Is it your wish today to waive your right to a prelim within the 21-day period?
Yes, sir.
Okay. Do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
I find the waiver of the prelim to be knowing, voluntarily, and accurately made within the knowing of the prelim within 21 days. And we will reset the preliminary examination. So what's the time frame? Are we 2 to 4 weeks or?
I believe if you give us 2 weeks, we should be able to see if we can get that discovery.
So Ms. Rothstein, it'll take about 2 weeks or a week to look at the recovery and then a week to talk to your client about it?
Yes.
All right. So we'll set it for 2 weeks, whatever's available, 2 to 3 weeks.
July 2nd at 8:30.
July 2nd at 8:30. All right, we'll set it for July 2nd at 8:30. That'll be live in person on the 6th floor City Hall of Lansing, unless I hear differently from the parties. And Mr. Moyer, if we'll writ you over if you're still incarcerated. Anything else for the record in 2601-554, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Rothstein?
No, Your Honor. Thank you.
All right, Mr. Moyer, we'll see you on July 2nd at 8:30. Thank you for your appearance today. And then, Mr. Berman, are you, I don't know what case you're here on.
I'm William Watkins with Ms. Robinson.
Okay.
Yes,
All right. And are you ready to go on that case?
we are.
All right. All right, so we're on the record in docket 26-01517. That's People of the State of Michigan versus William Watkins. Appearances for the record, Mr. Berman.
Thank you, Your Honor. Randall Berman on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Watkins, who's appearing over Zoom.
And sir, you are William Watkins, is that correct?
Yes, sir.
And you can hear me all right, Mr. Watkins?
Yes.
All right, thank you. This is the time set for a probable cause conference. Mr. Berman, how are we proceeding? Would you like to defer to Ms. Robinson?
I believe it's being left set, but I can defer to Ms. Robinson for further information. I do note she's brought up a concern with regard to a discovery request that I have already emailed and requested.
All right. Is that a fair statement, Ms. Robinson? To the best of your knowledge, we're leaving it on for prelim, and Mr. Berman has acknowledged that you've made a discovery request.
That's correct, Judge. We are going to leave it set for a preliminary exam. I did let Mr. Berman know that we are missing the search warrant accompanying affidavit to that, which I know he's on top of and getting that done as we speak. So we'll be ready for next week.
All right. So we've left on for preliminary examination for June 25th at 8:30. Anything else for the record in 26-01517, Mr. Berman?
On behalf of people, Your Honor.
Ms. Robinson.
No, Your Honor, thank you.
All right. You should be all set, Mr. Watson. We'll see you live in person Thursday, next Thursday morning at 8:30. Okay, sir?
All right. Thank you.
You're welcome.
Your Honor, we're ready to go on Castillo.
Castillo. We'll see you, Mr. Berman.
Thank you, Your Honor.
All right, so we're on the record in 26-00775. That is people of the state of Michigan versus Levon Castillo. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Castillo. Mr. Castillo is present at council table. He's standing to my right.
And sir, you are Levon Castillo, is that correct?
Yes, Your Honor.
Thank you. This time set for a probable cause conference. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Sartz?
At this time, I'll defer to defense counsel.
All right, Mr. Sartz, how are we proceeding?
Thank you, Your Honor. Mr. Castillo requests his preliminary examination as currently scheduled. We have discovery. We'll be ready to proceed next week.
All right, so we're leaving on for prelim. It was previously scheduled for June 25th at 8:30. So next Thursday at 8:30, that'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 26-00775, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Sartz.
Nothing from the defense, Your Honor.
All right, Mr. Castillo, we'll see you next week at 8:30 at this time. Thank you for your appearance.
Yes, Your Honor.
All right,
We're prepared for Roy Hudson.
and that's Mr. Lee covering for Mr. Raleigh.
That is correct.
All right. All right, so we're on the record in 26-01459. That is people of the state of Michigan versus Roy Hudson. Appearances for the record, Mr. Stevens, Mr. Smith.
Yes, thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
I don't know where I got Mr. Stevens. Mr. Lee.
Assistant Public Defender John Lee, appearing on behalf of Roy Hudson. I am standing in today for Jacob Raleigh.
All right, and sir, you are Roy Hudson, is that correct?
Yes, Your Honor.
All right, thank you. This time set for a probable cause conference. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Lee?
I defer to defense counsel.
Mr. Lee.
We're going to be leaving this on for the preliminary exam.
So we'll leave on for the previously scheduled preliminary examination for June 25th at 8:30. That'll be next Thursday at 8:30. Anything else for the record in 26-01459, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Lee.
Nothing for the defense. Thank you.
All right, Mr. Hudson, we'll see you next Thursday at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing, just like we're here today. Okay, sir?
Yes.
All right, you should be all set. Thank you for your appearance today.
Thank you, sir.
All right, so we're waiting. So my understanding, Mr. Rothstein, is we're waiting, is on Tommy King to be placed in
Yes,
one of the rooms? All right,
Yes.
and then, and Deshaun Brown.
Oh, Taiwan Brown.
Taiwan Deshaun Brown.
Okay.
All right. And then Ms. Donnelly, you're here for a few 9 o'clocks.
No, I was gonna cover for Tyler, but he's here, so
Okay.
I'm just doing, it's trying to get an adjournment for.
Wanda Dabois.
Wanda Bois,
Wanda.
yes.
All right. And my understanding, she's in rehab.
She's in, no, she's hospitalized.
Hospitalized?
Crest.
Okay, school crest.
So,
We kind of got a note on that, I think.
yeah, Marcy says you got an email from
Yeah.
she's on Eaton County probation. I've been in touch with them too, and they don't know how long she's gonna be there, so I was just gonna ask for 30 days.
All right, let's go ahead and put that on the record.
And she hasn't done the PSI yet too. so
Right.
We need to get that done.
Okay, we got a call from Eaton County Probation who stated she supervises Miss Wandabwa, and she's currently in Stonecrest and will be there for a bit longer. So she's gonna contact the public defender's office, and then Miss Wandabwa will reschedule. Miss Wand, we know where she is.
Yes, yeah, like I said, I've had a call from Stonecrest themselves. They reported it to me back on June 2nd, and then,
Perfect.
yeah, we talked to each other yesterday.
All right, so if you have any contact, as you know, if you have any contact with her, have her contact Ingham County Probation so she can do pre-sentence.
Yes,
Okay. All right, so we're on the record in docket 26-00796. That is people of the state of Michigan versus Tana Wandabwa. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Ms. Donnelly.
good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant Tana Wandabwa, who is not here yet.
We received, and I'll make a record and then you can supplement the record. We received notice that from the probation agent in Eaton County that Miss Wandabwa is at Stonecrest. And they were asking for, and then they were going to indicate that they were going to contact Miss Donnelly. It sounds like Miss Donnelly was already contacted.
Well, no, I don't know if that was before or after. It was yesterday. I did talk to the Eaton
Okay.
County probation officer to inquire if she knew how long she was gonna be at Stonecrest.
All right. Yeah, this was on June 16th. That we got a message that she was in Stonecrest, but Dee is currently in Stonecrest, and we do need a updated or a pre-sentence PSI, so we're going to reschedule. And she's been at Stonecrest for a little bit of time. Is that correct?
Yes, like I said, I got a voicemail from someone at Stonecrest on June 1st.
All right.
Or my office did. It didn't actually go to me first. It
Okay.
came to me on the June 2nd. It was actually Chief Public Defender that the message went to on the 1st.
Yeah, and we had from May 8th, 2026, we were to rid her out of Eaton County, and we were going to contact probation to see it, and then now she's in Stonecrest.
Yeah, what happened was she was put on probation on May 14th.
Okay, all right, Dan, Mr. Smith, is that your understanding? We're going to adjourn this matter and then have her do the PSI when she's out of Stonecrest.
Yes, the people stipulate to adjournment.
Do we have to rid her out of Eaton County, do you think?
I know, there's no warrant.
Okay.
There's no, yeah.
Okay. All right, so let's reschedule, and you're about 30 days.
I would say yes. She could be released in as little as a week, or it could be more long-term. Ms. Wandabwa is already under a guardianship. She was already in or had placement in an adult foster care.
Okay.
So that might be might make more steps for her.
All right, so let's adjourn the sentencing to 30 days out.
July 16th at 9.
July 16th at 9 o'clock. All right, we'll reschedule the sentencing for July 16th at 9 o'clock. We'll waive the defendant's appearance. She is currently at Stonecrest. There's a civil order out there in regards to a guardianship, I would think. Is that?
Yes,
okay?
She is under a guardianship.
Okay. All right, anything else for the record in 26-00796, Mr. Smith?
Nothing from the people, Your Honor.
Miss Donnelly.
Nothing for defense.
All right, we're all set on Miss Wandabwa.
Yep. You got it there, Your Honor, right there. Yeah. I like to remember, like Wanda.
That's a harder name to say.
But like Wanda, but then Wa, you know. Yeah.
All right, and then Miss Rothstein, you're waiting for your clients.
Yes.
All right, so just let me know when you've got anything ready to go.
Will
Okay.
do, Your Honor. Thank you.
Bless you, Miss Donnelly. Thank you.
Thank you, Your Honor. Everyone.
Mr. Berman, how are you? Pretty good. Pretty good.
May be wrong in our system. Could you look this piece up?
I thought I got a new phone this week, and I thought I threw off because we do everything by duo in the court system. So we have to, and it was not reading my phone. It's like, I just,
You gotta call your IT and have them register your new phone, even though it's the same number that happens.
yeah, I thought I blew it. I blew up the whole court system with this. This morning we were able to fix it, so it worked out. It worked out. But just the new phone is going to do that. We didn't have this problem without phones.
But of course, you had to come in and do everything.
Yes, which one one of the judges had a wet sign a search warrant. They had not done it before. I did it all the time,
Right.
and boy, you would have thought that it was the biggest obstacle of all time. That's how I got to know the judges, is because you get to go to their house and see where they live, and they made you coffee, you know, and at 3 a.m, you know.
That's it.
Not happening.
All rise.
All right, I will see everybody when you have something ready.
Yes, Your Honor. Case was bound to read the probable cause conference. I forgot to get rid of the
Dan,
preliminary. hearing.
When do you want us to bring up,
Henderson.
use the prelim? I mean, you want to wait till we get all the other stuff done?
Yes.
Okay.
So even though she's in wherever, we're still handling this to all the grounds, right?
What is Henderson is a
Prelim.
prelim today? I mean, this our docket for today doesn't have any prelims on it. Oh, does it? False report. Oh, he's running a false report.
I'll give you a tip. All you have to do is ask him then what happened.
What?
And you get it. Direct examination and then what happened.
I don't,
Just to clarify, I don't know.
yeah.
I prefer.
Yeah, someone here.
2601-282. That is People of the State of Michigan versus Reginald Henderson. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May I please report Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Henderson. Mr. Henderson is present to my right.
And sir, you are Reginald Henderson, is
Yeah.
that correct? Thank you. This is the time set for a preliminary examination. Mr. Smith, how we proceed?
Your Honor, at this time, the people are going to ask for adjournment of this matter. It has been brought to our office's attention that the defendant is going to plead into the specialty court in 55th. We need time to have the defendant screened into that specialty court, and I believe he's accepted the way to enter that plea to the case under those conditions.
Is that a fair statement, Mr. Sartz?
Mr. Henderson is interested in waiving his timeline this morning, Your Honor. Correct. These mental health court pleas are always contingent upon clearing clinical eligibility. We expect the turnaround time will probably be at least a month, Your Honor, because we need to get him screened. And then if he is successful in the screening process, then we'd also need to get the case transferred down to 55th. So respectfully, Your Honor, Mr. Henderson understands the term of his offer. He's agreeable with waiving his timeline, and I request that we adjourn this out about 6 weeks.
All right, and I know that Judge Hillman takes his own plea and then goes to the specialty court.
Yeah.
All right, may I inquire of Mr. Henderson of his waiver of the 21-day rule?
Please, Your Honor. Thank you.
Okay, Mr. Henderson, you understand you have a right to a preliminary examination within 21 days of your date of arraignment.
Yes.
Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime.
Yes.
You are represented today by Attorney Jacob Sartz, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it will be your wish today to waive your right to a prelim only within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within the 21-day period, so we can see and get this reviewed for specialty court, for the specialty court. Is it your wish today to waive your right to a prelim within 21 days?
Yes.
Mr. Smith, the people also waive their right to a prelim within 21 days.
We do, Your Honor.
All right, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And then we'll set this out like a control date, just to make sure that everything's reviewed and that it goes to specialty court. So we'll set it out for prelim, and then you can tell us if we need it or not. And it would be, I'd say 6 weeks. Let's set out prelim for 6 weeks.
Thank you, Your Honor.
Yeah, you have to adjourn next week's, and then we'll set this prelim out for 6 weeks, and then you can let us know if we need that prelim date or not. Hopefully it's in specialty court by that time. It may not have been. This was the date for prelim, so you don't have to do any. You don't have to adjourn. You don't have to adjourn anything next week.
I get in paperwork.
Yes.
Yeah.
We'll get you some paper.
You'll at least get a notice
Oh.
to appear, but you may not need that notice because you'll already be in specialty court.
Oh, okay.
Yeah, for prelim, 6 weeks out.
Why have been storming outside?
So July.
Is it still? No. That was last night.
At what time?
9.
All right. So as a backup date, we set it for July 31st at 9 o'clock, just to make sure that all the review is set. And you'll get notice to that effect. You may or may not need that, depending on if it's already in specialty court. Okay. All right. Anything else for the record in 2601-282, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Sartz.
Thank you, Your Honor. Mr. Henderson, you have been getting access to CAS and CMH while you've been in jail, right?
Yeah.
So you feel good today? You understand what's going on?
Yeah, I met with the clergyman. He was happy.
Okay, and you've also had a chance to meet with CAS and CMH?
Yeah, I'm doing mental therapy now.
All right,
perfect. I'm in our program, I'm doing all the classes.
Excellent. So do you have any concerns about your mental health this time? Are you doing okay?
Yeah, I can, I need to see them more often.
Okay.
That makes it more important.
Thank you, Your Honor.
All right. Mr. Henderson, they're going to review you for the specialty court, and we set a backup date just in case. All right.
So you got a bond?
Yeah, you got a bond of $500 on this file. Okay. And you have also a court with Judge Flores on Monday.
Oh, what for the assault and
The
battery?
assault misdemeanor.
Oh,
Yes.
Miss.
Yeah.
Okay.
So you'll be brought over for the Monday
Oh,
case.
okay.
You should be all set, sir. Thank you.
Thank you, Your Honor.
All right, Mr. Smith, where are we heading next? I see Mr. Tyler Smith here.
Oh,
Yeah, Mr. Tucker.
Tucker?
Malone Tucker. Let's see you, Mr. Berman.
Yes, Your Honor.
Subpoena that said 9?
Mr. Tucker?
Yeah.
Yes, he did.
Yeah, this is a,
The other guy didn't?
Originally, Mr. Perkins was on board. Get there, 9.
yeah, this is a violation of probation concerning Malone Tucker. And that's your case, Mr. Smith. Is that correct?
All correct, Your Honor.
All right. All right, so we're on the record in docket 2502880. That is People of the State of Michigan versus Malone Tucker. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Tyler Smith.
Tyler Ray Smith from the Office of Public Defender here in Ingham County. I do appear on behalf of Mr. Tucker, who's standing to my right.
And sir, you are Malone Tucker, is that correct?
Right.
All right. This is the time set for a violation of probation concerning this matter. The arraignment, it was previously arraigned on May 11th. We had some discussion about the no contact order on May 21st. And on June 4th, it was adjourned for the probation violation hearing for today's date, June 18th. Mr. Smith, how are we proceeding today, or would you like to defer to Mr. Smith?
I defer to defense counsel, Your Honor.
Mr. Smith.
Yes, Your Honor, I've discussed the matter at some length with Mr. Tucker. I reasonably believe he wishes to enter a plea to the single allegation.
All right. All right. May I inquire of Mr. Tucker of his plea to the single allegation?
Naturally, Your Honor.
All right. Mr. Tucker, you understand you have a right to hearing in this matter. You have the right to counsel. Mr. Smith has been assigned to represent you. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that? The allegation made is that you non-technically violated your probation and it was brought by Mr. Hanna, your probation agent, and it was co-signed by Judge Ward on May 1st, 2026. It's my understanding it is your wish to plead to the non-technical probation violation. Is that correct? All right. I'm going to raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? It is alleged that you failed to adhere to no contact order according to DeWitt Township Police to a police report. How do you admit to failing to adhere to a no contact order?
Just with contact. So.
The no contact order, I'm assuming, is towards the, let's see.
It's Ariana Platt.
Ariana, yeah, it's the complaining victim in this matter. And I'll get it is Ariana Platt. Concerning the DeWitt Township Police report, did you have contact that you knew you shouldn't have with Ariana Platt?
Yes.
Okay. All right. I find the admission to the no contact order to be knowing, voluntarily, and accurately made. And that would be violation 13. They're not 13 violations. That's just how we label it. And then Mr. Smith, you had the opportunity to see the probation violation recommendation concerning this matter. There's also an email that it looks like May 23rd email, and then a note from Brendan indicating some DV programming would be in order before the no contact is lifted. Did you want to see any of that? Or have you seen it, all that?
I have not seen it. I think I'm obligated to make sure I can examine it.
All right. All right. So let's make sure you get to see everything the court has before we sentence, and then I'll provide you can argue on the allocution.
Thank you.
All right. So Mr. Metz, you can apply. That's what I have.
Yes. Absolutely.
All right, then Mr. Malone, we'll give your attorney a chance to see the recommendation, and then we'll go from there, okay? Tracy Perkins is on Zoom.
Yes, Your Honor, I arranged for Mr. Perkins to appear, as I believe he was looking at a notice to appear that said 1:30.
Okay, I've got June 18th at 9 a.m. on my notice to appear.
It's entirely possible it was an error.
Yeah.
I'm just making sure you can be here one way rather than
right.
This is the original.
Oh.
Those are the original.
I believe it's had adequate time to.
All right.
Review.
All right, so we're back on the record in docket 25-02880. Allocution, Mr. Smith.
Yes, Your Honor, having had an opportunity to review an email purportedly from the complaining witness, Ms. Platt, I am prepared to make allocution. The recommendation from the probation office calls for a weekend of jail and continuation of probation, along with revocation of status under 7694A. I'm not going to argue about revocation of 7694A because I believe the statute requires that it be revoked. I think that's a harsh result, but unfortunately there is no room for discretion. Inasmuch as any additional sanction, I respectfully submit that in light of the fact that apparently the complaining witness has no interest in remaining separated from Mr. Tucker, the risk here seems to be quite low. I am not particularly convinced that any jail would be necessary here. There's no reasoning supporting protection of any individual. And the fact that this case is becoming public, that Mr. Tucker will have a public conviction for a case that does come with some opprobrium from the public, I'd submit that's a sufficient sanction on its own. If the court does see fit to impose some incarceration, I'd certainly ask that it not exceed 3 days. That's already right the edge of putting Mr. Tucker at risk of harm to his earnings, to his business. So respectfully, I request the court forbear from any incarceration sanction at this point, certainly with the understanding that if there's any further violation of this type, jail is inevitable. I don't believe there will be any further violations of this type. And given the communication from the complaining witness, I would respectfully request that the court remove the no contact order as a condition of Mr. Tucker's probation.
All right, thank you. Mr. Smith, anything from the people?
Nothing further. We would ask that the court follow the recommendation from probation.
Mr. Tucker, is there anything you'd like to say to the court before the court passes sentence?
No, sir. Thank
All
you.
right. All right. I agree with Mr. Hanna. I also agree with counsel. I'm going to sentence the defendant to 3 days, but I'm going to place it in abeyance. So there'll be no upfront jail, okay? If you come back to me, you know you're going to jail. I mean, that's that you owe me 3 days is what we're doing. But I understand you're working but I'm not going to lift a no contact order until you complete the four sessions of domestic violence that's been requested. Okay. So I'll continue on probation. So let's continue probation. And this is what people forget is probation is just another way of sentencing you. So if you violate enough times, I'm just gonna send you to jail. Okay. What we're trying to do is we're trying to make sure this doesn't happen again. But we've had some concerns concerning no contact order, and I know that the victim has reached out to you. Okay. And so you're really only I can trump the no contact order. Okay. If the victim says it's okay, I say it's okay. You can just you indicate I'm still under no contact order until I get another order. Okay. And you most likely will get another order after you complete the 4 sessions of domestic violence. So I'm going to say continue probation. I'm going to place you on 3 days in the Ingham County Jail, and then I'm going to place it in abeyance. So there'll be no upfront jail. And then per the probation, Mr. Hanna's request, we'll get the 4 sessions of domestic violence. I think he's ordered the DV program / ABR. So once you're able, I'm going to revoke the 769-4A. So that status is revoked. So this will be a public hearing. So realistically, in order to keep Mr. Hanna, to keep your probation officer from indicating another violation, just complete the DV, the 4 sessions. And then he's going to come to me and ask for the no contact to be lifted. And then as long as we don't see each other again, the 3 days are placed in abeyance. If we do see each other again because there's a violation of no contact or because you haven't done something that Mr. Hanna wants to be done, then we're going to readdress those days. All right. All right. Anything else for the record in docket 2502880, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Tyler Smith.
No, Your Honor, thank you.
All right, Mr. Tucker, you should be all set. Thank you for your appearance today.
Thank you.
Your Honor, we'll call Perkins.
All right. Mr. Perkins. And this is the PA 53 contempt. All right. So we're on the record in 2600638. That is People of the State of Michigan versus Tracy Perkins. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Tyler Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Tracy Perkins, who is appearing separately via Zoom. I do apologize. I think there was an error of time of day. Mr. Perkins usually would be here in person, and he has attended in the past. I arranged for him to attend via Zoom for lack of a better alternative.
All right. So, sir, you are Tracy Perkins, is that correct?
Yes, Your Honor.
All right. Thank you. This time set for a PA 53 violation, a no contact order. So this was set on June 4th, June 18th at 9 a.m. was set. And I put a tether for the contempt hearing. The PR bond was reinstated. So this $1,000 bond was PR bond was reinstated, and we set it for June 18th at 9 a.m. pursuant to what we said on the record. That's June, and then a notice was sent to 5760 Selfridge Boulevard concerning the June 18th date at 9 a.m. Is that a fair statement, Mr. Perkins? You thought we'd set it for this afternoon, is that correct?
Yes, Your Honor. I received 2 letters in the mail from 5760 Selfridge, but they were for the date of the 11th before it got changed.
Yeah, it was set for June 11th at 1:30, and then we changed it to June 18th at 9. At 9, that was, let's see. So the June 11th date was set out June 4th. And then it was followed up with a letter sent out June 4th. So they're both sent on June 4th, which may indicate some of the confusion. Mr. Smith, so I understand a little bit of the confusion. I can just reset it for hearing.
Your Honor, at this time, for the record, the complaining witness or the protective party, Ms. Miller, is here present in court. The people were prepared to move forward on the violation hearing today, but as a result of this PA 53 no contact violation, there was additional action, additional charges that were looked into by our office. We are going to be filing those charges. So in order to preserve the defendant's rights with regards to the underlying violation, we are going to stipulate to an adjournment of this matter. Again, our office will be filing additional charges in this matter, and we'd ask that the court hold that off until that new cases.
Right, and then if you end up issuing on this charge, you can tell us if we need the hearing date. Yes. Because I understand that those are similar facts, and then a jeopardy would attach on some of those facts. Is that your understanding, Mr. Smith? We'll adjourn this hearing and wait to hear from the prosecutor's office if they plan to file charges. That pretty much would take care of this file.
Yes, opposing counsel made a very comprehensive summary. I would request the court do just so. And just to be clear, the allegation here is under identical facts to the ones underlying these potential new charges.
All right.
So it certainly would give rise to an issue regarding Mr. Perkins' record.
Absolutely. So we will adjourn the hearing, and then we'll see if we need that hearing or not, but we'll adjourn the probation violation hearing. Mr. Smith has indicated that this is probably going to end up in new charges. And so we may not need that hearing. So the complaining victim should know that these are the same charges that may end up in a new file, in a new charge. So once the new charges are filed, then that'll do away with the probation violation file. But we'll adjourn the probation violation hearing for, and I would say 2 to 4 weeks.
Yeah. 4 weeks.
Yeah. We can do it in the afternoon. Yeah, let's read it. July 16th at 10 o'clock. We may or may not need that hearing. We'll wait to hear from Mr. Smith, whether these are going to arise in new charges. So Mr. Perkins, you're still under a no contact order. You should be under a GPS tether concerning this matter. So you're supposed to have no contact with Miss Miller. That includes any time between June 18th and July 16th. And then we'll see if this is going to end up in new charges. If it does end up in new charges, you'll have to be arraigned on the new charges that it's arraigned that the new file will incorporate. All right, sir.
Yes, sir.
All right, so we're waiting on new charges from July 6th to July 16th at 10 a.m. Anything else for the record in docket 2600638, Mr. Smith?
Your Honor, I would just indicate to the defendant that no contact means no third party contact,
Okay.
no indirect contact, no contact at all.
I will indicate that the pretrial release order that was signed by myself on June 4th has no contact with Haley Miller, no indirect or direct contact with Haley Miller. So nobody should be contacting Miss Miller on your behalf. And then under the other, I place no contact with Haley Miller or be within 1,000 feet of where she works, lives, or goes to school. GPS tethers required, 1,000 foot exclusion zone and victim notification if possible. That's all a part of this file. So there should be no direct or indirect contact with Miss Miller. All right, sir?
Yes, sir.
All right.
Nothing further from the people.
All right. Anything else from the defendant, Mr. Smith?
No, Your Honor, thank you.
All right. All right, Mr. Perkins, we'll see you on July 16th at 10 o'clock if you're not arraigned sooner on the new charges. All right, sir?
Yes, sir.
All right. You should be all set. Thank you for your appearance today.
Thank you.
So I think we have Attorney Rothstein. Any one of her
Anything she's ready to go on.
Well,
So
the jail hasn't
Ro-
put
Miss-
anybody in.
So have I see Mr. You have all right. So I can go on King and Brown, but you'd be responsible, Ms. Rothstein, for letting them know what we're due here. Because for whatever reason, they're not. I know where they are. They're in Ingham County Jail, so I'm not going to bench warrant them. But
Right.
they're not here. They're not present. But we can waive their appearance and go on those cases.
Okay.
All right. Because both King and Brown are Taiwan Brown are incarcerated, and then you have one more probable cause at 11:30 with Mr. Samoras. Is that correct, Mr. Smith?
Yes.
Okay. That's
I do not.
It's no, you do not, Ms. Rothstein.
Okay. No. Okay.
Yeah, that's so. So let's go on the record in 2601540. That's People of the State of Michigan versus Tommy King. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. King, who, for whatever reason, wasn't available to be with us from the jail.
Yeah, right. So we're going to waive Mr. King's appearance. He is in jail. He should be placed on Polycom. He is not being placed on Polycom. This was set for 8:30. It is now 10:09. So there's some question as to whether they're going to find a place for him. But Ms. Rothstein has indicated that she'll let Mr. King know what we do here. So we're going to waive his appearance. Mr. Smith.
Oh, here comes someone.
Oh. So is this Mr. King or Mr. Brown?
Mr. King.
King. All right, this is Mr. King. Ms. Rothstein, did you want to meet with Mr. King in a breakout room before we go forward?
Yes, please.
All right. So, Mr. King, I'm going to place you in, let's see. I'm going to place you in room 1, and then I'll place your public defender also in the same room. And then we can go on Brown. I'll ask if what we're doing on Brown. They're a little late on Mr. King.
I believe he's, there was an offer on that.
All right.
So he may plead to that one, and I think we're just gonna leave Brown set.
All right. And then Miss Tijerina, we'll wait to hear from Mr. Samoris on that.
Yes. Mhm.
All right. All right, just come get me when we're ready, Marcy.
Okay.
All right.
All right.
All right, we'll see you in a little bit.
Yes, Your Honor.
I sent you an email, Mr. Smith.
Vita, are you done? Are you ready?
Yes, we're ready.
Oh, okay. All right, Amy. Okay.
Oh, yeah, Reggie was doing that dance all the way down the hallway.
Yeah.
So then this is the, then I do want. Okay, gotcha.
All contender, yeah. They do like Chipotle, they do, that's Panera, like Panera, so yeah. Something of nature. Maybe it's like
Available over to the lobby for escorts.
Oh, everybody's rising.
All right, you can be seated. All right, Ms. Rothstein, did you want me to bring back Mr.
King, Your Honor.
King?
Yes, please.
All right, let me bring him back. All right, so we're on the record in 26-01540. We've had appearances for the record. Ms. Rothstein, did you have the opportunity to speak with Mr. King in a breakout room?
Yes, I did.
All right. What, if anything, are we doing at this probable conference? Mr. Smither, would you like to defer to Ms. Rothstein?
Oh, Your Honor, at this time, the people would move to amend the count one down to a misdemeanor use. It's my understanding that the defendant's going to accept that offer, and we will place this, or we'll need a PSI for sentencing.
All right. So this is a use of, so it's amended to the misdemeanor use of cocaine. Is that correct, Ms. Rothstein?
Yes, it's a misdemeanor use of a controlled substance, which I believe carries with it a maximum possible penalty of 1 year in jail.
Absolutely. And let me see. I just want to make sure that. Okay, so it's cocaine. And it's 1 year and or what's the 1,000 or 2,000?
$1,000.
$1,000. All right. And that's pursuant to MCL. What's the
333.74042B.
333.74042B.
Yes.
And is Ms. Rothstein, is that your understanding of the plea offer? Is we'll plead to an amended count one misdemeanor use of cocaine, a 1 year and or $1,000 under 333.74042B.
Yes.
All right. May I inquire of your client, Mr. King, of his misdemeanor advice of rights?
Yes, you may.
All right, Mr. King, you can hear me all right, sir?
Sure.
All right. You have certain rights in this misdemeanor plea. Is that your understanding? You'll be pleading guilty to the use of cocaine That's an amended count one with a penalty of 1 year and or $1,000. Is that correct, sir?
Yes, Your Honor.
All right. You have the following trial rights in this misdemeanor case, and I'll walk you through those trial rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan at trial. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've said on the record, or threats it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor use of cocaine instead. Is it still your wish today to plead guilty to the misdemeanor use of cocaine, the 1 year and or $1,000?
Yes, sir.
All right. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm gonna bring your attention back to June 8, 2026 at 1923 East Michigan Avenue in the city of Lansing. And Ms. Rothstein, were we going to use the facts for count one or the actual use of cocaine, for the factual basis?
The use of the cocaine.
All right. All right. So I'm going to bring your attention back to June 8, 2026 at 1923 East Michigan Avenue in the city of Lansing. Were you at that location on that date and time, Mr. King?
Yes, sir.
And at that time, did you use the controlled substance of cocaine?
Yes, sir.
And you didn't have a prescription for it, is that correct?
Yes, sir.
And you knew it was cocaine when you were using cocaine, is that correct?
Yes, sir.
All right. Anything towards a factual basis, Mr. Smith?
Nothing. The people are satisfied.
Ms. Rothstein?
No, Your Honor, thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. And we'll sentence. So we will set a sentencing date and we'll refer to probation. And the sentencing date is set for, we'll need 6 weeks. Yeah.
July 30th.
July 30th at 8:30. So we've set sentencing for July 30th at 8:30. Mr. King is being held on a bond of 1,000 cash or surety. Mr. Stevens, did you want to be anything else to come to the court's attention?
No, Your Honor.
All right. Ms. Rothstein, anything to come to the court's attention?
No, Your Honor.
All right. All right, Mr. King, probation will either be out down to see you, or if you're out, you should go into probation for their sentence, but they'll be down to see you, and the sentencing date is set for July 30th at 8:30. Okay, sir?
Sure.
That's all for the record in 26-01540. Thank you, everybody, for your appearance today. And then Ms. Rothstein, you're on Mr. Brown. Are we going to leave Mr. Brown on? All right.
We are. There is an offer. I don't know if we should place it on the record or not, but we are just leaving it on for prelim at this time.
Well, let's leave it on, and then we'll let you tell Mr. Brown once you see him what the offer is, and we'll work from there. But we'll waive his appearance today.
All right.
All right. So we're on the record in 26-01555. That's people, the state of Michigan versus Taiwan Brown. Appearances for the record, Mr. Smith.
Thank you, Your Honor. I may it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Brown, who is in the Ingham County Jail.
All right. This is the time set for a probable cause conference. It was previously set at 9 o'clock. It is now 10:25. We're waiving Mr. Brown's appearance as we know that he is incarcerated, but he's not been placed on Polycom. Mr. Smith, how are we proceeding on this probable cause conference, or would you like to defer to Ms. Rothstein?
I defer to defense counsel.
Okay, Ms. Rothstein, how are we proceeding today?
We are going to leave this on for the preliminary exam for next week at this time. If something changes, I will certainly let the prosecutor and the court know.
All right, so we'll leave on for the previously scheduled preliminary examination for June 25th at 9 a.m. and allow Ms. Rothstein to talk to her client concerning this matter. But we'll leave on for June 25th at 9 a.m. That's next Thursday at 9 a.m. Anything else for the record in 2601555, Mr. Smith?
Nothing from the people, Your Honor.
Ms. Rothstein.
No, Your Honor, thank you.
All right, and if while we're here, because we've got an 11:30, if Mr. Brown is placed on Polycam, we'll let him know that we'll at least let him know that it was left on to next week. All right, ma'am?
Yes, thank you. I would appreciate that.
All right. All right, that's all for the record in 2601555. Ms. Rothstein, I think you're all set. We have one more PCC.
All right, thank you.
You're welcome. All right, and then Mr. Smith, I think we have Mr. Samoris at 11. All right, Miss Tijerina, can you hear me?
Yes, I'm sorry. I
All
thought
right.
my
That-
headphones were acting weird.
It's absolutely not your fault. I was muted.
Okay,
All
I
right.
was freaking out.
All
Okay,
right.
sorry.
You're perfect. So we're on the record in 26-01110. That is People of the State of Michigan versus Ananisa Tijerina. Appearances for the record. Mr. Oh, ma'am.
Good morning, Your Honor. Grace Chevalier requesting permission to practice under MCR 8.120 under supervision of Assistant Prosecuting Attorney Dan Smith.
All right. And how do you spell your last name?
Shavallier.
So pronounce that for me. Chavalier?
Chevalier.
Chevalier. Okay. All right. And you only have to make that once today, and you made it. So you're good, and you're under supervision, Mr. Smith. Mr. Samoris, your appearance for the record.
Good afternoon, or good morning still, I guess, Your Honor. Peter Samoris here on behalf of the defendant, Ms. Tijerina, who is present via Zoom video conferencing.
And ma'am, you are Anisa Tijerina, is that correct?
Yes, Your Honor.
All right, thank you. And you can hear me all right, Ms. Tijerina?
Yes, Your Honor.
All right. This is the time set for a probable cause conference. Ms. Chevalier.
Chevalier.
Yeah, it's going to take forever.
Like Cavalier. but
Yeah.
Shot.
Chevalier.
That is surprisingly helpful.
Yes.
I had Ms. Kroc-Molny from the city attorney's office, who I can say now correctly. She just phonetically spelled it for me and emailed me like, please pronounce my name like this, and that worked, All right, so Ms. Chevalier, how are we proceeding?
We are, after discussion with defense counsel, we will be setting for a prelim examination in 2 to 3 weeks. Defendant has already waived the 21 days.
All right. And is that a fair statement, Mr. Samoris?
Yes, Your Honor, with of course the court's approval, and I've had productive discussions today again with both Mr. Smith and Ms. Chevalier, and I think there will be a resolution. Not to go into too much detail, but the sobriety court in 55th District Court might be an option. Of course, there it's kind of not in flux per se, but Judge Allen did retire,
right?
And so I just want to find out, make sure all the T's are
like who's
crossed.
Who's going to be appointed?
Yeah. I guess that's a consideration.
Yeah, I would think that's a very big consideration. All right, Ms. Tijerina, the 21-day rule was waived on June 4th, 2026, and we'll set for prelim in this matter. And we'll check with Mr. Samoris' schedule. I would think it'd be 30 days or so.
That's fine by me, Your Honor.
Just to get it all worked out. So we'll set for prelim. Give me a couple of dates, and then we'll run them by Mr. Samoris' schedule.
4 weeks since July 17th.
So how does July 17th work?
I think technically I'm scheduled for a trial that day. I don't think it's going to go, but I just wanted to, just in case it does.
Let's try
24th. I'm wide open the following.
Okay, let's try the 24th. Yep. So it's the 23rd or 24th.
Right.
Okay. How are you looking on the 23rd?
That's fine.
Okay. Right. So we'll set for July 23rd at 9 o'clock. With the 21-day rule waived, we're set it for prelim on July 23rd at 9 o'clock. And Ms. Tijerina, you'll get notice sent to you at your last known address, which was on Christine Drive. Is that still a good mailing address for you, ma'am?
Yes, Your Honor.
All right. All right. We've set it for July 23rd at 9 o'clock. Anything else for the record in docket 26-0110, Ms. Chevalier?
Nothing more from the people, Your Honor.
Mr. Samoris?
No, Your Honor. Thank you.
All right. We should be all set. Thank you everybody for your appearance. You're all set, Ms. Tijerina.
Thank you, sir.
Your Honor, may I approach has nothing to do with the case.
Absolutely. And Cavalier helps with Chevalier. So that's good.
Well, I think we've exchanged emails before. Either that or maybe I'm wrong.